Welcome to Lesson 7.11, Understanding and Supporting Investigations. In your Candidate Information Bulletin, we are in the Security Operations domain. We are in Key Area of Knowledge A, which is Understand and Support Investigations, and B, which is Understand Requirements for Investigation Types. Our lesson topics are going to include digital forensics, types of investigations, evidence handling, forensic investigations, NIST resources, and an ISC² related certification. So forensics is a process of using scientific knowledge for collecting, analyzing, and presenting evidence to the courts. Digital forensic is the application of science to the identification, collection, examination, and analysis of data while preserving the integrity of the information and maintaining a strict chain of custody. Let's go through that one again. We said that digital forensics, so not just forensics, but digital forensics, application of science to the identification, collection, examination, and analysis of data while preserving the integrity of the information, so making sure the information hasn't changed, and maintaining a strict chain of custody for the data. Digital forensic investigations are generally conducted in response to an information security or human resources or a criminal or a civil incident, and the evidence may or may not necessarily be used in court. So just jumping all the way back to Lesson 1, let's just do a criminal versus civil refresher. When we talked about criminal law and civil law in Lesson 1, just reviewing criminal law first. Criminal law, the basis is a law must be broken. The intent is that there must be intent required. The burden of proof is beyond a reasonable doubt, and prosecution can only be by the government. Remember, criminal laws are those to protect individuals or society. Civil, the basis is a contract violation or a dispute between parties. The intent could be intentional, could be accidental. The burden of proof is lower. The burden of proof is preponderance of evidence, and prosecution is between individuals and companies, or individuals and individuals, or companies and companies. But it's not by the government. So that's our criminal and our civil. So digital forensic investigations can include criminal investigations, civil investigations, or administrative investigations. Criminal investigations are designed to assist law enforcement with obtaining evidence, because remember that it's only the government that can prosecute a criminal case. So we're going to be assisting law enforcement to obtain evidence. Now, because this is a criminal investigation, compliance with the Fourth Amendment of the Constitution regarding lawful search and seizure of evidence is required. In a civil investigation, the objective is to provide evidence of wrongdoing or damage. Civil litigation may include, but isn't limited to, intellectual property theft, contract violations, patent violations, patent infringements. And so a warrant or a court order may be required to be able to obtain evidence. So here we're going to do a warrant or a court order. Administrative are either internal policy-based or could be regulatory-based, and the investigations are generally to support internal questions, concerns, or findings. So 3 types of investigations: criminal investigations, civil investigations, and administrative investigations. So in doing an investigation, the investigator is going to need to handle evidence. And it's not always obvious at the beginning of a case if the evidence is going to be used in a criminal or civil proceeding, meaning is this evidence going to go to court? So incident handlers should treat every investigation as if it will lead to a court case. Incident handlers must establish and maintain an evidentiary chain for all physical and electronic evidence collected during the investigation, and we're going to look specifically at those requirements. You want to be aware that information that goes to a criminal or civil proceeding may become public record. So company confidential information, whenever possible, should not be included in evidence unless absolutely necessary. An evidentiary chain, which is also referred to as a chain of custody. So an evidentiary chain, or you might see this term chain of custody, requires that the following information must be logged and procedures followed. This includes logging where, when, and who discovered the evidence, who has handled the evidence and when, who has had custody of the evidence, during what time period, and how was it stored, and if the evidence changed custody, how and when the transfer occurred. If an investigation leads to a court case, it must be proven that the evidence was securely handled and not tampered with. And that's what you're going to use your evidentiary chain or your chain of custody to prove. A digital forensic investigation has a number of stages, and at each stage, the data that we're working with kind of transforms from one type to another. In the collection stage, this is where we're collecting evidence, we're just accessing media. Then we move into the examination stage, and in the examination stage, now we're extrapolating raw data. It doesn't mean anything yet. Where the digital forensic investigator is going through an analysis phase, and in the analysis phase, working with information, trying to extract information. Once a digital investigator starts putting their report together and is reporting out, now that information is going to be culled down to evidence. So in our reporting phase, we've got evidence that we're working with. And then at the end of the investigation, where we want to archive the data, now we're archiving, but we're archiving all of it. We may be archiving the media, the raw data, the information we've used for analysis, and the evidence. So it's the original and the image media, documents, and all ancillary materials. So we're going to look a little bit more at these stages, where we're talking about collection, examination, analysis, reporting, and archive. So let's start with collection. So our first step is to secure the scene so that evidence does not get contaminated or removed. The possible sources of data do need to be identified. The sources of data could include, but not limited to, volatile data, that's data that's in memory, that if you turn off the power of a system, you're going to lose. Storage devices, removable media, backup media, a mobile device, documents, and a variety of logs, such as firewall logs, IDS, operating system logs, application logs, and even logs from an internet service provider. The relative value should be assessed as the amount of effort to acquire different data sources may vary widely. So the digital investigator is going to have to try to determine what he should be collecting and prioritize them and look at the work factor compared to the value. All collected data at this stage should be handled as potential evidence. Then the investigation will move into the examination stage. Forensic examination should be conducted only by trained personnel. It is really easy to contaminate and to destroy evidence. There are a number of open source and commercial forensic products available for use during the examination stage. Now, whenever possible, examination should be conducted on exact images or replicas and not on the original data source. So the process of disk imaging generates a bit-for-bit copy of the original media, including its free space and slack space. Free space is unallocated space on the drive, and slack space is unused space that may hold residual data. So it may hold residual data of files that have been deleted. So let's emphasize that whenever possible, examination should be conducted on exact images or replicas, not on the original data source, where the examiner will make an image. The image generates a bit-for-bit copy of the original media, including free and slack space. Our free space is defined as unallocated space. Our slack space is unused space that may hold residual data. After the relevant information has been extracted, the forensic analyst can then study and begin to draw conclusions. Now, a key component of analysis is correlating the data from multiple sources. It may be from the drives, it may be from the logs, it might be from a mobile phone, it may be from browsing history. In digital forensics, the absence of evidence doesn't necessarily mean that nothing happened. So if our analyst or our investigator does an investigation but doesn't have any hard evidence or isn't able to draw any conclusions, it doesn't mean that nothing happened. It just might mean that the evidence isn't available to us, or the evidence has been destroyed or contaminated. The analysis phase may lead us right back to additional data collection. During the analysis, there may be a request to collect additional data and then examine and analyze. Reporting is the process of preparing and presenting the information from the analysis phase. Forensic reports should be written with the audience in mind. So are we going to court? Are we giving this to our security professionals? Is this report going to executive management? Is it going to opposing counsel? So the report should be written with the audience in mind. Regardless of who the audience is, though, all conclusions must be substantiated. And if an event has more than one plausible explanation, both or all should be presented. If it turns out that the evidence is incomplete, it may be possible only to present findings and not to present conclusions. But remember that the absence of evidence doesn't mean that nothing happened. And when applicable, remediation recommendations should accompany the report. At the conclusion of an investigation, we're going to want to archive all of the components associated with the investigation. So throughout the archive period, original data and all related media, documents, and ancillary items should be secured. Legal counsel should be consulted as to the retention period. And then post-retention, the original data and all related media, documents, and ancillary items should be securely destroyed. Now, as to be expected, there's an excellent NIST resource on this topic. It's SP 800-86, which is a guide to integrating forensic techniques into incident response. It's a really interesting read. I would suggest that you download it, read through it, and add it to your digital library. For those of you who are really interested in this topic or are already working in the field, ISC² does have a certification specific for cybersecurity forensic professionals. It's called the CCFP, and it's a Certified Cyber Forensic Professional Certification. And I would encourage you to go out to the ISC² site. You can read about the certification and what the requirements are, and perhaps add that to your CISSP. So you'll have a CISSP plus be a CCFP. So that brings us to our 7.11 review. We talked about forensics and then digital forensics, the type of investigations, criminal, civil, and administrative, some rules around evidence handling. We looked through the phases of a digital forensic investigation. I introduced you to some NIST resources and to the ISC² CCFP certification. So that brings us to our Match the Meaning. We have a whole host of terms that it's really important that you know and that you're comfortable with. So down the left-hand side, we have our evidentiary chain, volatile data, disk image, slack space, free space, public record, a civil suit, and administrative. So take the time you need, put me on pause, match these up, then come on back and we'll go through them together. Let's go through our 7.11 terms. An evidentiary chain is custody documentation. Now that's also referred to as a chain of custody. Volatile data is data that's held in memory that's lost without power. A disk image is a bit-for-bit copy. And it's going to be an exact replica. It's going to have the slack space and the free space as well. The slack space is unused space that may hold residual data. Now, it may hold residual data because at one point there was a file allocated to that space. Free space is unallocated storage space. Public record means the information is available to everyone. A civil suit is litigation between parties. That's in contrast to a criminal suit, which is going to be between the government and an individual. And then administrative generally refers to an internal investigation. So those are going to be your best matches for our 7.11 term. So let's end our lesson with looking at some CISSP exam tips. Incident handlers should treat every investigation as if it will lead to a court case. Examination should be conducted on disk images and not on the original data source. And lastly, in digital forensics, the absence of evidence doesn't necessarily mean that nothing happened. So thanks for joining me for this lesson, and I look forward to seeing you in the next.